Supreme Court says it is adopting a code of ethics for the justices, and for many of us, we say, you mean you didn't have one before? Nope, they didn't. Joining me right now is Lin McCraw. Lin McCraw, excuse me. I'm so sorry about that. Lin, trial attorney with McCraw Law Group. Lin, listen, how is it that the Supreme Court, everybody else has a code of ethics, how is it the Supreme Court has gone this long without a code of ethics?
Well, it has to do with the fact that we have, three different branches of government, and there's nobody to hold them accountable but themselves. And they have not felt the need to have a code of ethics. I am flabbergasted as well. I mean, it's amazing to think about because our normal judges have codes of ethics. We as attorneys have code of ethics, and our codes of ethics have teeth to them. This particular code of ethics, when I read it, I looked at it and I was shocked at the fact that it had no teeth to it whatsoever. I mean, it's full of shoulds rather than shalls, and there's no enforcement mechanism at all. So I think it really has more to do with a public PR move than anything that's actually going to change much at the Supreme Court.
Interesting. So really, this is more of like a PR statement that we would get, like a generic statement. If a company is accused of doing something wrong, then the company says, we hold ourselves to the highest standards. We are looking into this and we'll be dealing with it immediately. And you can rest assured that this company will not tolerate that. But really, there's nothing to it, right? It's just a PR statement. That's basically what this is.
It's not just a PR statement, but what they did is they took some of the rules that they have for other federal judges, and they put them together, and then they softened them to some degree because they took the shalls out and said, you should do things like not sit on a case if you've got a financial interest or that sort of thing, or if you have a bias. The problem is, if somebody has a true bias and they really want to sit on something, you have to have an enforcement mechanism. And the court could very easily have said, they could have set up an enforcement mechanism such as maybe the other justices that didn't have the problem when the complaint gets filed would review the complaint and rule on the complaint as to whether or not the judge needed to be not sit on that particular case and that sort of thing. But there's nothing in there other than a statement of aspirations, I would call it.
So Lin McCraw is a trial attorney with McCraw Law Group. Lin, my mind is sort of blown by what you're telling me here, that they took code of conduct, code of ethics for other justices and actually diluted them to apply to themselves. Is that because this is I can't even. This would just oversimplifying, of course, because that's what we do. This would be like saying speed limit 55 unless you don't want to, and then speed limit 55-ish. I mean, they basically have added an ish. They shall-ish recuse themselves from cases where they might have something going on. Ish? That's what we've done here, right?
It's not exactly that. First of all, they took the code of ethics from other judges, not justices, but other judges. So that would have been the trial judges. Okay. And some of those simply don't apply to the Supreme Court or can't apply because, the Supreme Court has rules as to how many votes a person needs to get to whether or not you can even hear the appeal. And if somebody recuses themselves, that can have the effect of denying a person their right, their potential right to court. Yeah. So there are some differences here that mandated some changes, but there are quite a few of them you look at and you're thinking, well, if they were serious about this, they would have an enforcement mechanism. And I think that what we've seen with Supreme Court justices on both sides of the aisle, we've seen some problems that those of us look at and say, you know what, this just doesn't smell right.
Yeah.
I think it's created a perception that perhaps they're for sale, a perception that maybe you have to pay to play and that sort of thing. And they're addressing that because the Supreme Court's authority really comes from their goodwill. It comes from the fact that people see them as fair arbiters. That's how it grew up in our nation. That's how it grew into the third branch of government.
Sure.
And the Supreme Court justices are very cognizant of that, so they felt the need to have some type of a ethics code out there. But I do think that over, I think what we're going to see is eventually we will see some problem. Some Supreme Court justice will take some action that is against these codes. There won't be an enforcement mechanism, and then the codes will eventually change, so we will have some. But it's going to take probably some more time before that occurs.
So it's going to take impropriety before we finally fix the problem. Even though we've got a framework in place, it'll take actual impropriety and outrage before finally something gets done. Can it be done, Lin McCraw, trial attorney with McCraw Law Group, is this something that has to be done from the judicial branch, or is this something that that Congress could look at and say, we're going to draw up a code of ethics and we are going to codify this? Or does the Supreme Court simply strike that down by its own authority and say, no, you can't do that? We're getting into the weeds here a little bit, I suppose.
Yeah, you have asked a $64 question, right?
Yeah.
Because Congress has said we have the authority to issue rules for the judiciary, and Congress has issued rules for different parts of the judiciary that have been upheld. But, Congress has not issued any rules directly saying that to manage the Supreme Court itself. And theoretically, the Supreme Court could just simply not follow them. And there's no, like I said, there's no enforcement mechanism that Congress could have to force the Supreme Court to follow them.
Is there any way, Lin McCraw, is there any way that, I know there was a lot of focus on Clarence Thomas, the RV and the deal with Harlan Crow and all that kind of stuff. I know his name came up an awful lot, but Sonia Sotomayor had some issues too over books and property sales and things like that. So as you pointed out before, it's also it's bipartisan issues here that we're talking about. Is there any mechanism in place right now to impeach a sitting Supreme Court justice if, for instance, the impropriety rises to a level that is so frustrating for the American people that we feel something has to be done?
Absolutely. Impeachment could occur through Congress just like it could occur for any other elected official.
Okay.
In the federal government, just like it would for president. It would be held under the exact same standards.
If that happens and the defendant, who would be one of the Supreme Court justices, wished to sue, and it went all the way to the Supreme Court, you see where I'm going now, could we end up in a real dilemma with the Supreme Court trying to rule on its own code of ethics based on impeachability or anything of that sort? It sounds like a constitutional crisis that we're talking about by not having an enforceable framework in place.
Well, first of all, the justice that would theoretically might bring this type of action, there wouldn't be an action to halt an impeachment, but you very well could have an action that could say, well, this impeachment rules, the rules for this impeachment don't allow due process, or they don't allow me to present the evidence I need to present, or whatever, and that, of course, would go up through the court. So, yeah, it creates just a myriad of problems. I understand what they're trying to do, and I understand the limitations that they may have from their sitting members, because the sitting members. There's a lot of tradition in the Supreme Court, and they traditionally have done a lot of things like they definitely go and testify in Congress. They do stuff like go to law schools and give lectures, and they're not really paid for that, but they are reimbursed travel expenses and that sort of thing. The real issue is, how do you draw the line between what people look at and say, that's good because it helps the administration of justice, and bribery. Where do you draw that line?
Yeah.
And then how do you enforce it? I just wish that there was some enforcement provision in this that simply doesn't exist right now.
Lin, great conversation. Thank you so much for being with us today. Really, I just enjoy the hell out of it. Thank you so much. Lin McCraw, trial attorney with McCraw Law Group. Hope we can get you back on again in the not so distant future. Really great talking with you. I appreciate you there, my friend. Thank you.